Lordships, the last item 40. This relates to the release of the passport. Facts, sir, your Lordship have heard it. The facts are almost covered by a judgment of the Supreme Court, which I'll place. I have informed the counsel for CBI, Mr. Naik. Will your Lordships kindly be pleased to take it up before rising, because there's a great cascading effect for my green card and other 40 last item.
After lunch, if you can tell.
After lunch, I had informed him.
He says, we had informed him after lunch. He said that some matter is there in Supreme Court, 3 o'clock onwards will be free.
Okay.
So your Lordship, please at 3 o'clock.
3 o'clock.
My lord, I beg your Lordship's pardon. My lord, item number 39 also same.
That
Okay.
item before that.
39.
Okay.
So,
Yes.
Your Honor,
Pardon, my lord, mentioning a matter that is Criminal Revision 124 of 2024. That is, my lord, challenging the order of conviction. May be listed. Next.
Conviction matter are coming. Revision matter, I think it is only if it is revision against vigilance or CBI, those matters are coming. See the assignment. No, another is CBI matter is there also. Please pass on. So the assignment to me is revision relating to CBI, then revision relating to in the nature of bail under the special act, and revision relating to vigilance from 2015 onwards. So if it doesn't fall, then you mention. Why are you accepting the memo? Yes.
Big pardon, my lord. And I filed one IA for extension of time, my lord.
For what?
My lord, so I'm filing memo, my lord, for
No, for what?
for extension of time, my lord.
Extension of time for what?
My lord, for to surrender, my lord.
Okay.
And another, my lord, one criminal appeal. He has been convicted under special act law. So I on a SC/ST act, my lord. So
Conviction is there.
yes, my lord.
Okay.
And that matter was listed.
All right.
And,
Your Honor, I have filed CRLA for bail. Filed CRLA for bail. And the offences were under section IPC, POCSO, and SC/ST Act. Later, the office objection I also complained for a change of nomenclature from CRLA to BLAPL. Accordingly, I have filed IA, and I got the case was registered as CRLA 199 of 2024. Since then, the matter has not been listed.
What is the number you said?
CRLA 199 of 2024.
Okay, it will be listed. All right, note it down, it will be listed.
Yeah.
Supplemental list item number 1.
Director, whether notice was sufficient or notice have to switch up a chicken. Yes, so what is the CRLA for?
The bail man.
For bail,
SC/ST
provision is there.
Stop, yes. On
No.
2nd April.
2nd April. So, Mr. Pujari, we are giving 1 week time. So, let it come on 15th. The Land Council for the state submitted that notice on the informant has been made sufficient on 2nd of April 2024 in order to give opportunity to the informant to engage the counsel of his choice, his or her dekhi likhive. Put up this matter in the week commencing from 15th April 2024. If any counsel is engaged by the informant, the renama shall be placed on record and his name shall be reflected in the cause list in the top of the brief. Yes. And you have received the case diary and
Yes,
other.
Item 2.
maybe. My lord,
Item 3.
May I please, Your Lordship? May I please, Your Lordship? Petitioner was arrested on 23rd 5th 2015. On the rejection order of the learned OPID court on 2 counts that the petitioner is the director of the company and IO has not been examined. Now, immediately all out of 4 IOs, DSP in rank, they all has been cross-examined. And other directors who have been also released on bail. Now, Lordships, I am heavily relying the judgment of Ravi Prakash Lordships, which says prolong its incarnation is against fundamental rights.
Since when you are in custody?
23rd 5th 2015. Almost 8 years.
You have never been released on even
No,
interim
Lordship. One interim order was granted by my lord.
bail?
He could not fill
Abhel the same that surety you could not furnish.
Lordship. For that purpose, I am also relying Ashok Sandeep case, Lordships, which was 10 lakhs was surety grant ordered by the court. Honorable Supreme Court only says it will be 25,000 as personal bond.
No, it's all right, but as it appears that somebody has approached this court.
Lordship, CRLMC, one director.
Dev Kumar Panda, he is
Lordship, one director, CRLMC on the count, Lordships. After examination of 4 IOs, the DSP, another another DSP came with a document. He was not charge sheeted as a IO. He came with a document that these are the documents requires to be examined. I am the witness. That was challenged before this honorable court. This honorable court granted stay, saying
so
that
one of the investigating officer is to be examined.
he was not in the charge.
It's all right. Now the prosecution called him for examination. That order you have challenged. That was allowed by the trial court, and against that order you have come, stay has been granted. Right.
One of the director.
Right.
Not this man.
No, that's on Debo. So, Mr. Patro, that date is correct. 2015. So virtually 8 years. What you are doing?
No, all the document I have, my lord.
No, let us say that
On 28/9/2020, my lord, this honorable court granted him interim bail for 3 weeks.
Abhel Koleni se to
Thereafter, all the orders I have kindly applied.
Abhel Kori Parleni se on cash surety bodhe thibo na
20 lakh cash.
Cash surety. Then this Dev Kumar Panda's latest position is it is to be listed on 10-4.
Yes, yes.
On the last occasion, on the grab of same thing, they have taken time.
No, I have not taken time last occasion.
Your friend.
Are the learned counsel for the petitioner, learned counsel for the state. State of Orissa, special counsel for the state of Orissa, Mr. Patro. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 23/5/2015. And he has been charge sheeted under section 420, 467, 468, 471, 406 of the Indian Penal Code and section 6 of the OPID Act. And earlier, the petitioner approached this court for bail in BLAPL number 10456 of 2019, and as per order dated 28/9/2020, taking into account the period of detention of the petitioner, and the slow progress of the trial, this court granted by order dated 28/9/2020, granted him interim bail for a period of 3 months from the date of release. Inter alia, with the condition that the petitioner has to furnish cash security of rupees 20 lakhs. The Learned Counsel for the petitioner submitted that the petitioner could not furnish such cash security for which he was not released from custody. The Learned Counsel further submitted that at present, one of the investigating officer, who is not a charge sheet witness, was summoned to be examined by the prosecution, which has been challenged by one co-accused, namely Devkumar Panda, before this court in CRLMC number 2795 of 2023, and the proceeding has been stayed by the and the stay order is still continuing. The Land Council relied upon the decision of the Honorable Supreme Court.
Ravi Prakash versus State of Odisha.
What is the citation? Is this the way you place?
Dita jaka net ର judgment ମୁଁ ତାକୁ କହିଛି net ରୁ ଖାଲି କାଢି ମୁଁ ଏଟା କହିଲି.
What is the citation?
Ravi Prakash versus State of Odisha 2000.
Ravi Prakash
versus State of Odisha
versus State of Orissa
2023 live law SC 533.
Live law SC
533. This is regarding prolonged incarnation, and second judgment is Lordship Ashok Sandeep Singh versus Uttar Pradesh.
Ashok Sandeep Singh
versus Uttar Pradesh, SLP criminal 3314. SLP criminal double.
କୋଉଥିରେ report ହେଇଛି କଣ?
এটা online କେବଳ reported ହେଇନି ସେ
ରବି ପ୍ରକାଶ ଟା ବାହାର କରି ଦେଖିବେ ଲାଇଭ ଲୋ ହେଲା ତାର ଯଦି relevant paragraph ଥିବ ମତେ ଦେଖେଇବେ ତାପରେ ମୁଁ ଯୋଉ paragraph ଟା କହିବି quote କରିବି.
3 judges to Honorable Chief Justice of
Land
India.
Counsel for the Mr. Patral and Counsel appearing for the State of Odisha Special Counsel oppose the prayer for bail. The Land Counsel for the petitioner submitted that all other petitioner is one of the directors of the company and all other directors have been released on bail. Land Counsel for the state opposed the prayer for bail and submitted that the company in which the petitioner was one of the director has accepted deposits and from different depositors in different schemes, and so far as the petitioner is concerned, an amount of rupees 16 lakhs 7,000 and 117 has come to the personal account of the petition. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the stage of the trial, and since the trial has already been stayed by this court, are the instance of the co-accused, I'm inclined to release the petitioner on bail, subject to condition that he shall furnish. So now you furnish cash security of ₹5 lakhs.
Lordship, ତା କତିରେ କିଛି ନାହିଁ, ସବୁ ସିଜ୍ ହେଇଛି, ସେଇଥିପାଇଁ 20 ଆପଣ
ସେଇଥିପାଇଁ ଆପଣ ଲାଇଭ୍ ଲର କପିଟେ ବାହାର କରିପାରିଲେନି ନା କଣ କହୁଛି?
ମୁଁ ନେଟ୍ ରୁ ଆଜି ସକାଳ 2ଟା ଯାକ ଜଜମେଣ୍ଟ ବହୁତ କାମରେ ଆସିବ ଆଜ୍ଞା। 10 ଲକ୍ଷରୁ 25,000 ଅନେବଲ୍ ହେଇଛି, 25,000।
Yes, next. No cash security, just releasing order. Yes, next.
Grateful,
Item 4.
May it please your lordship. It was lying on the road. It was seized and 680 kg of 720 grams of ganja was seized.
Yes, Mr. Pujari, what is
May
this
it please your lordship. The truck was flying on the road. It was seized. 680 kilo 720 grams of ganja was seized from it. The driver and the cleaner, they were arrested on the spot. Nobody else was there. The petitioner, neither anything was seized from the petitioner, nor he was present at the spot. And he was taken on remand on 10/3/21.
Chindanarka is not filing the certified copy of plan trial court and is not in question to whether any further witnesses have been examined of PW2. Let a report be called for action for such purposes. Report asila. In the meantime, conjunction 2023 witnesses have been Four witnesses have been examined out of 23.
23.
And one was granted bail, he absconded. He is a man from Indradev Prasad alias Yadav.
He is the driver.
He is from which area?
He is from outside.
And you are a man from?
I am local.
Gajapati, acha. And what is your custody period?
Since 10/3/21.
10/3/2021.
My lord.
Charge sheet under section 20.
Charge sheet 20B to C. My lord. 25 and 29 also.
27, 29.
My lord.
So, in the talk, two persons were there.
Only two were there.
They disclose your name.
They have not disclosed because unknown persons they have.
In the FIR, your name is not there.
Not there. No.
Then you came into picture on what basis?
Mostly on investigation because they have not named
Mr. Tripathi during investigation. And anything was seized from the when he was
nothing.
FIR against those two persons who were apprehended.
Yes. The driver and the cleaner.
Pass on that FIR. 3 persons have been named.
My lord. He was named by that driver and the trainer.
Who?
That third person, Somnath Sahu or something.
Santosh Sahu.
My lord.
Who were apprehended? This
One and two.
Indra Prasad Yadav and Ram Dhobi.
My lord.
Are the learned counsel for the
having criminal antecedents criminal record. One.
what is that?
That he has been granted
First
bail.
page ଅଛି CD ର first page ରେ
He is in bail.
CD ର first page.
index ଯୋଉଥିରେ ଅଛି ସେଥିରେ ତଳେ
On verification of students accused involved, yes, he is involved. Mohana PS case number 120 of 2020. 20B2C. So what
My lord.
happened?
He is already on bail in that.
And are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted here. What is the custody date you said? 10/3/21.
10/3/21 taken on remand.
Right. That would be otherwise, because in this particular case, you are in custody since 2011-2020,
My lord.
and you were released on bail on
Only recently.
21/3/24.
My lord.
The petitioner was taken on remand on 10/3/2021. And he has been charge sheeted under section 20B2C, 27 and 29
25 and 29.
of the NDPS Act. The learned counsel further submitted that two persons, namely Indra Prasad Yadav and Jaguram Dhobi, while carrying commercial quantity of ganja in a truck, were arrested, and they disclosed the name of one Santosh Sahu. During interrogation, and accordingly, the FIR was lodged against three named persons, that is Indradev Prasad, Ram Dhobi and Santosh Sahu, and four unknown persons. Even though there is no incriminating material against the petitioner, but at a later stage he was arraigned as an accused and taken on remand in this case. The Land Council further submits that in the trial court only 4 witnesses have been examined. Out of 23 charge sheet witnesses. And therefore the bail application may be favorably considered. Land Council for the state, while not disputing that nothing was seized from the possession of the petitioner, in this case, submitted that the petitioner has got one criminal antecedent of similar nature. Mr. Pujari, Land Counsel for the petitioner, submitted that in the said case, this court has already granted bail to the petitioner in BLAPL number 10365 of 2023 as per order dated 21/3/2024. He has filed the copy of the bail order, which is taken on record. Considering the submission made by the Land and Counsel for the respective parties, nature of accusation against the petitioner, since nothing has been seized from the possession of the petitioner and his implication is based on confessional statement of co-accused during course of investigation, taking into account the ratio laid down by the Honorable Supreme Court in case of Tufan Singh versus State of Tamil Nadu, reported in 2020 80 Orissa, Criminal Report 641, and the slow progress of the trial, I am inclined to release the petitioner on bail. Will appear before the Land and Trial Court on each date when the case would be posted for trial, and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Yeah.
Item 5.
May I please, my lordship? My lordship, this appeal is against the 20
Item 10.
My lord. Appeal against the judgment dated 23/12/2013, log 2022-23, my lord. Be the appellant be convicted in 7 years, my lord, under section 420, 406, 467, 468, 420, 120B, and 66 of the IT Act, and 6 of OPDI Act. And petitioner in behind the bar, my lord, on dated 23/5/2022, clean incident.
What is the maximum sentence imposed?
7 years.
7 years for which offense?
467.
467.
Running page
So
73.
during trial, you are on bail or you are in
No.
custody?
No.
You are in custody.
My
Since
custody.
when you are in custody? 23/5/2022.
My lord.
Yes,
11 witness and examine lot, and the 20 witness case, but not a single witness is support and produce witness is to bear the seal and signature of the petitioner's appellant lot, not is the authorized person of the company. And petitioner is the one of the director of the LMH.
No witness has stated in.
No, any witness had produced an oral statement there, but not the sheet of papers will bear the seal and signature of the one in of the persons, the petitioners, and not the bear the authorized person of the company. The cross examination is there, Lord.
No. What was not produced?
Investigation officers, inquiry officers, and all the witnesses. Only says he the deposit amount in the favor of the company. He deposited the sum amount in the favor of the company. During the cross examination, I requested, have they any documents to bear the seal and signature of the persons? No.
So a document relating to
My lord.
deposit in
My lord.
in the company
My lord.
that was not proved.
Not single witnesses produced, not including investigation officers.
So what is that company? Name of the
Digital
company?
Revolution, Mala running page. Company Digital Revolution. Digital Revolution Technology Limited.
Digital Revolution Technology Limited.
PW1 statement cost exam running page 37.
Yes, Mr. Patron.
Miller.
He is in custody for 2 years and it's 7 years, so not likely to reach this appeal, 2024 appeal. So.
No, hear me, Lord. PW7 is the informant, Miller. Just categorically stated.
PW7.
Yes. Prince Kumar, Director of Digital Revolution Technology Limited, has duped large number of investors, giving false assurance to provide higher returns on the different schemes.
No, it's a general statement. What he is telling that let us say 5 persons have been deceived. They were asked to deposit and they have deposited. So what you are required to prove is the documentary proof, not that the persons who have deposited, they must not only give evidence, but there must be some documentary evidence to connect, to corroborate the evidence of those persons. This type of vague statements that he has cheated that would not do. How can you prove a case under 467, all these things? So which document was forged and in what way? This punishment imposed for the maximum punishment that was imposed was for the offense under section 467. I come to 467. Is a forgery of valuable security will. Whoever forges a document which purports to be a valuable security or a will, or an authority to adopt a son, or which purports to give authority to any person to make or transfer any valuable security or receive the principal interest so and so and to receive so and so. Okay, shall be punished with imprisonment for so and so. Okay. And forgery definition is at 463. Whoever makes a false document, false electronic record, part of the document or electronic record, with intent to damage or injury to the public, and making a false document is defined under section 464, that a person is said to make a false document or false electronic record who dishonestly, fraudulently makes signs, seals, so and so, so and so, with intention to be causing that such documents so and so was made, signed by the authority of the person. So which document, according to you, Milord, is a false document which the petitioner has made and that was utilized for the purpose as mentioned under section 467? Because forgery, if it is for a particular purpose, then forgery of some documents, if it is utilized for a particular purpose, then 467 would be attracted. And forgery has been defined under section 463, making of false document, which is again stated in 464. So a document must carry, or the accused must have made that document or signed, executed that document, even though he is aware that he was not the authority to do so, and he has with an intention to causing believe that this document has been made by an authority or a person. So what documents have been exhibited in this case? Seizure list.
That has been discussed in para 32 of the judgment, Milord. Similarly, to the offense on section 467, 468, 471 IPC.
Yeah, sir. Judgment of paragraph
32 I.
Running page 67.
Please.
Yes. With regard to the offences on section 467, 468, 471 of the IPC, read with section 66 of the IT Act, forgery, sine qua non of offences wherein the preparation of false document or false electronic record or part thereof is the condition precedent for the offence of forgery in the aforesaid background, going by definition of false document on section 464 IPC, when the accused is alleged to have made and transmitted computer generated documents without any legal authority by launching lucrative schemes for which he was not authorized, and thereby misuse the very purpose of organization from digital awareness to digital marketing, for which creation of website itself and various email on which transactions have been made, and the brochure itself, along with the launching of 6 number of the scheme through advertisement, which was seized by IO PW11 on production by PW1, which is one of the depositors in the company, wherein the accused either knew or to reason to believe that documents are forged for the purpose of cheating as such, sufficient to attract the penal offense on section so and so.
So the essential ingredients, one of the most essential ingredients that the prosecution is required to prove that forgery has been committed. Then forgery in respect of what document and for what purpose? Forgery for the purpose of cheating, forgery so that has been defined. So here, as you read out this paragraph number 32, the prosecution case is that the accused made and transmitted computer the accused
and transmitted computer generated documents
without any legal authority by launching lucrative scheme for which he was not authorized, and thereby misused the very purpose of the organization from digital awareness to digital marketing, for which creation of website itself and various e-links on which transactions have been made, and brochures itself, along with launching of 6 numbers of scheme through the advertisement, which was seized by Swanson production by PW1. So now you come to your exhibit list. Where is that scheme, etc., which was stated? It is only that seizure list you have proved. Where is that brochure? Where is that scheme? Where is the material that the accused has circulated it? But a computer ru generate heikini, let us say ABCD ku jaichi. Bibhinna scheme, and that for that they deposited. So you are to prove that accused had done this. These are the schemes. Scheme ku praman kari thante. A computer ru jaitila, a email ru jaitila. Se semanako pakhre jota pahonchithibo taku praman kari thante. Then in pursuance to that, they deposited the amount, and deposited, if it is deposited in which way, whether it was deposited in cash or it was deposited online, whatever it may be. So ei sabu anile apan gote link establish kari paribe je forgery heichi, taro emtia kichi scheme nathila, se scheme ku ye karichi, se authorized nathila. Apan khali gote seizure list praman karichindi, au konosi document nai jota se jo paragraph ra apan padhile 32 asun. Transmitted computer generated documents. Se computer generated documents kahi ଆପଣ କହିଲେ ଯେ ସେଇ କମ୍ପ୍ୟୁଟର ଜେନେରେଟେଡ ଡକ୍ୟୁମେଣ୍ଟସ ଗୁଡାକ ଆଣିକିନି PW1 ଦେଲା ଏବଂ ଯୋଉଥିରେ କି ଜଣା ପଡୁଥିଲା 6 ନମ୍ବରସ ଅଫ ସ୍କିମ୍ସ ପାଇଁ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ଇଏ କଲେ, ସେଗୁଡାକ ପ୍ରୋଡକ୍ସନ କଲା PW1 which was seized by PW11. So where are those documents?
Whether they are exhibited or not.
Yes, you have just proved the seizure list. Seizure list indicate করছি 5টা document 10টা document, but those documents are to be proved. those documents are to be proved, then can only the content should be, not that the seizure list, proving the seizure list, all the documents will be automatically proved. अच्छा जहाँ से डॉक्यूमेंट पठेइछन्ती सी मध्य कहिबा दरकार जेई पर्टिकुलर डॉक्यूमेंट टा एई स्कीम टा मते अक्यूज्ड सप्लाई कले एई कंप्यूटर रे अमको दिन तै सेथुरु मु डिपोजिट कली एति टंका एवं एई प्रोसेस रे कली तेणु फर्जरी हला एवं मु चीटिंग आसिला ताले गोटे ऑफेंस इंग्रेडिएंट्स हबो खाली गोटे सीजर लिस्ट टा प्रमाण करई देले केमथि हबो. So, and what he says, another thing, that there is no material that how the deposit was made. There is not a single document except this type of statement that we deposited, he deposited, the depositors deposited. So the amount, on what date, what mode, and what is the documentary proof? If that is not there, bald statement that the persons have deposited huge amount and they have been cheated, that would not be, you have to prove that case.
No, one to the some PW1 Miller, one of the investors. He has stated Miller.
Let us see here.
Miller,
PW1.
one of the investors. He has stated the mode of the deposit, Miller. I am one of the investor of the company. I know the accused, namely Prince Kumar, was the proprietor of the company. I could know about the company name and stylage YODRM from its Odisha head, Prashanta Mahalik, open an ID in the name of company in the year 2020 Miller. Initially, I deposited 15,000 to banks, namely SDFC and Axis Bank, online. I received the weekly return after 3 to 4 months. I got back 30,000 against my deposit, rupees 50,000. Thereafter, being encouraged by such return, I invested 1,35,000 on periodic established by creating ID in the name of my wife in the year 2020. In the month of May, a mass meeting was organized by Odisha head, so and where Prince Kumar, present petitioner, had also attended, and being influenced by them, I also convinced the depositor, and accordingly company would run for some months. A few months after, the said website of the company got closed. Then I, along with others, made the Odisha head so and inquired about the return of the money, but he did not respond.
ଏଗୁଡାକ ଖାଲି ମୌଖିକ ହେଲାନି ଆପଣ ଯୋଉ କହିଲେ
ସେ ପଇସା ଦେଇଛି ବୋଲେ କହୁଛି ଏଫଡିଏସି ଆଉ ଆକ୍ସିସ ବ୍ୟାଙ୍କରେ
ସମସ୍ତେ ତ କହିଦେବେ ଆପଣ କହିବେ ମୁଁ 5 ଲକ୍ଷ ଟଙ୍କା ଦେଇଦେଲି ହେଇଗଲା କି ଆପଣ କୋଉ ପ୍ରୋସେସରେ ଡିପୋଜିଟ କଲେ ଭାରି ଦି ଡକ୍ୟୁମେଣ୍ଟାରୀ ପ୍ରୁଫ ଆପଣ ଆରେ ଅନଲାଇନ ରେ ପୁଣି କିଛି ଡକ୍ୟୁମେଣ୍ଟ ହବ ନା ନାଇଁ ଅନଲାଇନ ଖାଲି କହିଦେଲେ ମୁଁ ଅନଲାଇନ ରେ 5 ଲକ୍ଷ ଟଙ୍କା ଡିପୋଜିଟ ଆପଣ ଏଇଆ ଗୋଟେ କହିଦେବେ
ଇଲେକ୍ଟ୍ରୋନିକ ଜେନେରେଟେଡ୍ ଡକ୍ୟୁମେଣ୍ଟସ
whether it is required to be proved in accordance with law. So how the electronics document is to be proved, that is to be proved, which would show that the transfer of this amount from one account to the other account. If the other account is of the company, if the other account is the accused so that is to be, that can be very well ascertained.
No, the material should be exhibited in the
right unless that is exhibited. So how can that is what is his submission, that there is no documentary proof or documentary evidence to support the oral evidence. If that is not there, how can you say? The IA number 105 of 2024. This is an application for bail. The London Council for the petitioner submitted that the maximum sentence imposed on the petitioner is 7 years. And the petitioner is in judicial custody since 23/5/2022, which should be evident from the impugned judgment itself in page number 2 under the heading of accused details. It is further submitted that since it's an appeal of the year 2024, there is no chance of early hearing. It is further argued that the maximum sentence of 7 years has been imposed for the conviction of the appellant under section 467 of the Indian Penal Code. But except the bald statement of PW1 and the IO, there is no documentary proof to support that any online transaction has been made and any amount has been deposited with the company and that the depositors have been cheated. The Land Council further argued that there are good chances of success in the case and balance of convenience is in favor of the petitioner and therefore the bail application may be favorably considered. Land Council, Land Special Counsel Mr. Patro for the appearing for the state of Orissa placed the evidence of PW1, Dinabandhu Parida, who is one of the investors of the company,
And PW7 also.
and PW7
Informant.
Devendra PW7 with the informant in the case. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail, stay realization of fine.
Item 8.
May I please, your lordship? 7 years of sentence, convicted under section 307 under 27 Arms Act, my lord. Jail in custody 6 years, near about 6 years, 3 months, my lord. Sentence is 7 years, my lord. Out of 7 years, my lord, 6 years jail in custody.
Are the Land Council for the petitioner, Land Council for the state, considering the submission made by the Land Council for the petitioner that out of 7 years of sentence imposed by the Land and Trial Court, the petitioner has already undergone more than 6 years of sentence, and it's an appeal of the year 2024. There is no chance of early hearing. And after hearing the Land Council for the state, I am inclined to release the petitioner on bail, stay realization of fine. That is reflected on the first page of the judge. That is right. There. So which should be evident in page number 2 of the impugned judgment under the heading of accused details. Yes.
Item 9.
May I please, your lordship? In this case, notice
fearless 504 में 2012 में भी 8 रन में 2012
This case, item 10, relate to 376. Yes, sir. ठीक है
It's a offense under 395
395.
or 376
No,
conclusion. So 395 and the sentence is 5 years,
5 years.
30,000 rupees fine in default to undergo RI for 3 months. So this, at least this accused has never been released on bail. This JCRLA 21 of 2012
Yes, sir.
And the judgment, after the pronouncement of the judgment, he must have been sent to judicial custody, even if he was not on bail. So 2012 means that period has already, he has undergone. What about the other one, Vaikuntha Bharkale?
He was on bail, Miller. 23/8/12.
And what about the last one, 504? Whether he was on bail? Yes, bail was allowed. So now the sentence is 5 years, 395, right?
Yes, Miller.
And as it appears, the judgment is a 4 persons who are facing trial.
Yes, Miller.
So let us see that charge Bharkale. So how 4 persons can be charged under 395? It is not that and others, that is not, that word is not there. Please come to the charge portion.
Yes, Miller. 47.
1, 2, 3, 4. Then it is mentioned that you means those 4 persons.
Yes.
On or about 13th day of June 2010 at about 10:30 p.m. at Palasuni under Manchester Police Station committed dacoity in respect of 8,000, 2 numbers of mobile, 1 suitcase, etc. of the informant, and an offense punishable under section 395. So how can be charged against 4 persons under 395? If it is not 395, let us say, what are the materials for the 394? FIR is against unknown person.
Yes.
FIR for unknown persons. Then how these persons were charge sheeted? What is the charge sheet? During course of investigation, informant was examined, spot was visited, so on, so witnesses was examined. Okay, who is the investigating officer? Let us see.
Ayub.
PW? Is paper book. TI parade report is available in page number 94.
Yes, madam. That's there.
So that indicates that one
Raju Vishnu.
Raju Behra, Vishnu Naik. They were the suspects, and the identifying witness is Bhavani Shankar Naik. Bhavani is PW?
4.
PW4, Bhavani.
Yes. Victim.
Naik, identifying witness and accused put to TI parade are Raju alias Rajesh Behra, then Vishnu Naik. Correctly identified, identifying witness correctly both the accused. All right. Then that is the only TI parade report. So let us come to that IO's evidence. IO के कितना नंबर सेकंड?
EW8.
Please place that evidence of that IO.
Yes, madam. On 14/6/2010, I was working as SI of Manchester PS. On that day, on the written report of Bhavani Shankar Naik, IIC Vishnu Charana Mishra registered in PS case number 142/2010 and directed me to take up the investigation. Exhibit 1/2 is the endorsement and signature of IIC Vishnu Charan Mishra, which I am acquainted. During course of investigation, the complainant
Bhavani Naik is the PW4, right?
Bhavani, yes.
Oh, okay. Please proceed.
During course of investigation, the complainant was examined, visited the spot. Complainant was sent to Capital Hospital for his treatment and other materials. Witnesses are also examined. Subsequently, on 22/6/2010, I got information from the SI Sitakanta Das of Sahidnagar PS, and I proceeded to Sahidnagar PS, and there I examined Raju alias Rajesh Behra, who confessed before me in presence of 2 witnesses that on the night of 13/6/2010, he had.
This Raju has been identified.
Yes.
Okay.
He has committed crime as he had described in Manchester PS case number 142 of 2010, along with accused person Vaikuntha Bhoi, Prashanta Naik, Vishnu Naik, and one Janu alias Janaki Bhoi. After recording the confessional statement of accused Raju, led me to his house on dated 22/6/2010 at about 11 a.m. and gave recovery of one black color money purse in which a colored passport size photograph of the complainant was kept. Xerox copy of the complainant matriculation certificate, one original PAN allotment
That
letter.
informant is PW4 Pravila?
Yes. Allotment letter of the complainant and 6 numbers of 100 rupees note were kept inside the money purse, which were also recovered. Subsequently, I recorded the confessional statement of the accused Raju alias Rajesh Behera in presence of witnesses. Exhibit 4 is the confessional statement of Raju alias Rajesh Behera. Exhibit 4/1 is my signature therein. The signature list exhibit 5 also prepared by me and 5/1 is my signature. On 24/10/2010, I submitted a remand report against Raju alias Rajesh Behera, Vaikunta Bhoi, Prashant Naik and Vishnu Naik, as they were forwarded in Sahidnagar PS case number 176 of 2010. On 25/6/2010, prayer had been made for TI parade of the accused Raju alias Rajesh Behera and Vishnu Naik. On 28/6/2010, I made an inquiry at the RTO office, Bhubaneswar, to establish the ownership of the involved Maruti Omni bearing registration number so-and-so. On 1/7/2010, owner of the involved Maruti van, Sushanta Kumar Samal, was examined under 161 CRPC and seizure of the Maruti van was conducted in presence of the witness from the owner Sushanta Kumar Samal. Exhibit 6 is the seizure list prepared by me and Exhibit 6/1 is my signature thereon. On 8/8/2010, I left the Maruti van along with its document in Jima of its owner Sushanta Samal. As per Jimanama, Exhibit 7 and Exhibit 7/1 is my signature. On 13/10/2010, made a prayer for issue of NBW against absconding accused person, namely Janu alias Janu Bhoi, and obtained NBW from Honorable Court of SDGM Bhubaneswar. On 18/10/2010, I submitted charge sheet against accused person Raju alias Rajesh Behera, Vaikunta Bhoi, Prashant Naik, Vishnu Naik, Janu Bhoi. Fight Manchester PS case number final reported 270 dated 18/10/2010 under section 395 IPC.
Okay, we'll go to the cross examination. First, you come to the evidence of that informant, PW4.
Yes, sir. I am the informant in this case. I know accused Vishnu Charana Naik and Rajesh Behera present in the dock. The occurrence took place on 13/6/2010 at about 10:30 p.m. I reached Bhubaneswar from Bangalore by Prasanti Express at about 10 p.m. After taking my dinner in a roadside hotel, while I was waiting near Master Canteen Chowk, a Maruti Omni van being driven by accused Rajesh Behera arrived near me. Another passenger was also waiting near me. Both of us boarded the vehicle. The other passenger got down from the vehicle near Rasulgarh. As I was to go to Polasuni, I remained in the vehicle. The vehicle went to a petrol pump of Rasulgarh Chowk. There the driver, Rajesh Behera, changed his position and sat near me. The other person who was sitting by my right side drove the vehicle. There were two other persons in the vehicle, one of whom was sitting in front seat and the other person was sitting by the side. My suitcase was kept in the dicky. After the vehicle reached Polasuni, they did not stop the vehicle. Then I shouted. Rajesh assaulted my head, squeezed my neck, and asked me to deliver all my belongings. He, along with the other person who was sitting by my side, forcibly took away my mobile phone and money purse from my pant pocket. They made me lie in between the front seat and the back seat and pressed my neck, chest, and by their legs. They sprinkled water on my face, took the vehicle here and there, and finally threw away me from the vehicle at Trinatha Bazar. Accused Vishnu Naik was all along assaulting me. He threatened me to kill in life. He was holding a bhujali. Some passerby reached me and brought to me to the road. I sat near a betel shop. They gave water to me. Thereafter, I sent information to my father through the mobile of my uncle. The PCR van arrived there and I was taken to Manchester PS. I filed a FIR at the PS. The FIR was scribed by my younger brother as per my instruction. This is the FIR marked as Exhibit 1, where Exhibit 1 by 1 is my signature. I was sent to hospital for my medical examination and treatment. Cross-examination by defense. Accused Prashant Naik. I am a diploma holder in computer science. At the relevant time, I was working in a private company at Bangalore. I have not filed nor given any appointment letter to police. I joined in service in the first week of January 2010. After the first time I was returning Bhubaneswar on that day, police had seized my train ticket. The train arrived at Bhubaneswar at about 9:30 p.m. I was in search of vehicle to go home. Therefore, I was waiting at Master Canteen Chowk. I cannot say the exact time when they threw away me from the vehicle. After the old man got down from the vehicle near Rasulgarh, there were 4 persons in the vehicle beside me. I cannot say the details of wearing appearance of the culprits. In the morning of 14/6/2010, I filed the FIR. I was in the police station and my father reached there. It is not a fact that no such occurrence took place and that I was deposing lie for the rest of the accused person cross-examination. It is a fact that I was not a proper condition at the time when FIR was written. It is a fact that there is no certificate of FIR. That the contents of the FIR were read over and explained to me, and that thereafter I signed thereon. I asked for the hair, and they told us the same to be the rupees 20. I had given the purchase receipt of the mobile to the police. I do not see my mobile phone in the courtroom today. Now, I had kept a sari, a lady's wristwatch of Fast Track company, some cakes, and my dress materials in the suitcase. I did not know Rajesh Behera prior to the occurrence. Police had conducted TI parade and I had identified the accused Rajesh Behera. I was examined by the police after filing the FIR. I was asked by the inspector sir and again the sub-inspector about the occurrence. I cannot say about the name of the passerby who rescued me. I cannot say the registration number of the PCR van I was in. Since when I was sent to hospital, it is not a fact that I was not taken from the Master Canteen Chowk in any such vehicle, that I was not returning from Bangalore, that the accused person had not given a lift to me in their vehicle, that they had not taken my mobile phone, money purse, etc., that I am deposing lie. Further examination. I had identified the accused person in the TI parade. I have signed on the TI parade report. This is the said report marked Exhibit 2, where Exhibit 2 by 1 is my signature. Cross-examination decline. Cross-examination for remaining accused person. I cannot say the total contents of Exhibit 2. After the TI parade, the magistrate asked me in what connection I identify the culprits. I explained the said fact to him. He noted down the said fact Exhibit 2 and and asked me to sign the report. Accordingly, I gave Exhibit 2 by 1. I had been to Manchester PS. The sub-inspector of the said PS took me to the Jharapura jail. I had never been to the police station after the accused person were apprehended by the police. About 30 persons were present in the TI parade, out of whom I identified the culprits. Some person were having mustache and some person having beard. After entering into the main gate, I was asked to sit in a room. The TI parade place was not visible from the room. I do not remember if any notice was received by me in connection of TI parade. It is not a fact that no such TI parade was held on that day. I am depositing.
So, Mr. Tripathi,
Yes, ma'am.
in the chief examination,
Yes.
this informant deposed as if he knew one person, one
Yes,
of the accused. His name is
Vishnu,
Rajesh Behera.
yes, Rajesh Behera,
Right.
Vishnu Swai.
Huh?
Vishnu Swai. Vishnu Charana Swai and Rajesh Naik and Rajesh Behera.
Vishnu Swai na kodi kouchi.
Swai Naik. Vishnu Charana Naik.
Kodi.
See, first. I am the informant in the case. I know the accused Vishnu Charana Naik and Rajesh Behera.
So, if first of all, if he knew them, right, prior to the occurrence, and he is lodging the first information report, then obviously would have named the persons in the FIR itself.
Yes, ma'am.
So that is not there. FIR is against unknown person.
Unknown person.
So that creates at least a doubt that about the acquaintance of the informant
Yes.
with those two persons, right?
Yes, ma'am.
Now, again, he says that Rajesh did this, Rajesh did that, and Vishnu did this. All these things he has stated as if he was a known person. You come to the FIR was lodged against unknown person by this PW4.
Yes.
In the cross-examination, of course, he has stated that I did not know the Rajesh Behera prior to the occurrence, and police had conducted TI parade, and I had identified accused Rajesh Behera.
Yes.
Then this particular line in the page number 74, that is above the cross-examination by the defense. In the morning on 14/6/2010, I filed the FIR.
Yes.
Just mark it. 14/6/2010 ତାରିଖ ଦିନ ସକାଳୁ ମୁଁ ଏତଲା ଦେଲି. ଇନଫ୍ୟାକ୍ଟ FIR ମଧ୍ୟ ଲଜ୍ ହେଇଛି 14 ତାରିଖରେ. ହେଲା? I was in the police station and my father reached there. Right?
Yes, ma'am.
Now you come to the evidence of the IO. IO is PW8. He says that on 22/6/2010, he got the information from SI Shitakanto Das of Sahidnagar. Shitakanto has been examined. Not examined. All right. I proceeded to Sahidnagar police station. I examined Raju, who confessed before me, like such and such. After confessional statement, accused led me and gave recovery of the black money, so and so. I recorded the confessional statement. Exhibit 4 is the confessional statement. And then TI parade was conducted on 25/6, so and so. So this particular statement which has been made by the investigating officer, that when he got the information that one of the accused has been arrested, he went there. There the confessional statement was recorded, and on that basis, the accused gave recovery of this money purse,
and
passport size photograph, then matriculation certificate, etc. এই যোড়াকে
Right.
siege কলা. So whether it was not required on the part of the prosecution
to
to
prove the same.
confront
Yes,
those
confirm
to the informant that
this
কারণ TI parade in respect of money purse has not been
Not-
conducted. Only in respect of this person has been conducted. So ବର୍ତ୍ତମାନ ଆପଣ ଏଇ ଯୋଉ ମନି ପର୍ସ ଆଉ ଅନ୍ୟାନ୍ୟ ଜିନିଷ ଏଗୁଡାକ if you peru the judgment of the this money purse has been proved to be MO1,
yes, ma'am.
photograph has been MO2 ହେଲା. So ଏଇ ଦିଟା ଯୋଉ ଜିନିଷ ଆପଣ ଆ ଜରିଆରେ ପ୍ରମାଣ କରି ପାରିଥାନ୍ତେ ଯୋଉ ଇନଫରମାଣ୍ଟ ଜରିଆରେ ଯେ ଇନଫରମାଣ୍ଟ ଟା ଆଇଡେଣ୍ଟିଫାଇ କରିଥାନ୍ତା ଏଇଟା ହଉଛି
Yes,
ତାର
ma'am.
ମନି ପର୍ସ. You please again see whether this informant PW4 has identified this property or it was proved only through the investigating officer. କାରଣ ଆପଣ ଯେତେବେଳେ ମନି ପର୍ସ ଟାକୁ TI parade ରେ ପୁଟ୍ କରୁନାହାନ୍ତି ତାହେଲେ ଇନଫରମାଣ୍ଟ କହୁଛି ଗୋଟେ ମନି ପର୍ସ ଟା ମୋର ଚୋରି କରି ନେଇ ଚାଲିଗଲେ, ସେ ମନି ପର୍ସ ଟା ସିଜ୍ ମଧ୍ୟ ହେଲା, ତାହେଲେ ମନି ପର୍ସ ଟା prosecution ର ଡ୍ୟୁଟି ନଥିଲା କି ତାକୁ to mark it as an MO through this
Informant, yes.
informant,
That are not asked, sir.
right?
Yes.
So it was just proved through the investigating officer. Investigating officer କହିଲା ଯେ ଏଇଟା ହଉଛି ମନି ପର୍ସ ଟା ମୁଁ ଜବତ କଲି ଆଉ ଏଇଟା ହଉଛି ସେ ସିଜିୟର ଲିଷ୍ଟ ଏବଂ
That was also not confronted to IU.
then how MO1 was proved? MO1 ଟାକୁ କିଏ ପ୍ରମାଣ କରେଇଲା ଆଉ କୋଉ ଦିନ ହେଲା ସେ ଇଏଟା ଦେଖିଲେ ଏକ୍ଜିବିଟ ଲିଷ୍ଟ ଟା ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟ MO1 ଟା କିଏ ପ୍ରମାଣ କରିଛି କୋଉ ଦିନ ଲିଷ୍ଟ ଥିବ ଗୋଟେ କୋଉ ଦିନ ସେଟା MO1 ମାର୍କ ହେଇଛି
Cross examination on age.
cross examination
Cross examination page 89.
89
Yes.
ନାଇଁ କ୍ରସ୍ ଏକ୍ଜାମିନେସନ ଇନ୍ ଚିଫ୍ ତାପରେ ସେ ଆଇଓ ଜରିଆରେ ପ୍ରମାଣ କରିଛନ୍ତି ଆଉ
Yes, yes.
MO1 and MO2 are the ଏଟା ହଉଛି ମନି ପର୍ସ ହବ ଏଟା ଫଟୋଗ୍ରାଫ ନୁହେଁ M1 ହଉଛି ମନି ପର୍ସ MO2 ହଉଛି
With
ଫଟୋଗ୍ରାଫ
photograph.
3 ହଉଛି ମାଟ୍ରିକୁଲେସନ ସାର୍ଟିଫିକେଟ
4 hଉଛି money.
Hmm.
6 number of 100.
EI period କେବେ ହେଇଛି ଡେଟ୍ ଅଫ TI period ହଉଛି 24/6/2010 ନା ଆମ ଡେଟ୍ ଅଫ ଆଇଡେଣ୍ଟିଫିକେସନ 26/6 ଉପରେ ଲେଖା ହେଇଛି ଆରେଷ୍ଟ ହେଇଛନ୍ତି 24/6 ଇଏରେ 26 ତାରିଖ ଦିନ ହେଇଛି Who are the other witnesses?
PW1,
Hmm.
the owner of the Maruti van in
Hmm.
which that incident took place. my lord.
Yes. What he has stated.
I do not know
Oh.
all the accused person in the dock
So no, that is
except
not.
yes, my lord, except Rajesh Behera. He was working as driver of my Maruti van,
Hmm.
white color, numbers one so.
Hmm.
He was also working in my as my driver on the date of the occurrence.
Hmm.
I do not know anything else about the case.
But the PW4 has not stated the registration number of that vehicle.
Yes. He only stated that the white color Maruti van.
3 has also not stated anything. So 4 hela eta. Who is 5?
Six is the father of the informant.
Hmm. Seven.
7 is the doctor.
Doctor.
Yes.
8 is the IO.
IO. The PW9 is the witness to the confessional statement of Rajesh Behera.
Let's take down. You are appearing in which case?
CRL 504/2012
What is your good name?
RR Naik.
Your power is there.
My lord.
Yes. So JCRL has been filed by one person, Raju alias Rajesh Behera. The same man has been filed another, that CRLA number 719 of
Yes, my lord.
so and so. So, एथर लिखि दियंतु अच्छा टोटल ट्रायल फेस करथिले केते जण 4 जण बोले
Yes. 4%.
राइट सो राजेश बेहरा रो तमने हबो CRLA 719 of 2012. Second one is Boykuntha is CRLA 21 of 2012.
Yes.
Then Vishnu Naik is CRLA 504 of 2012. Prashant is also CRLA 21 of 2012, right? এটা ওকে dispose of कर दो এটা देखिले JCRLA রেকর্ডটা দিন ଆରଟା ଦିଅନ୍ତୁ ତାର ଆଉ ଗୋଟେ ଯୋଉ କ୍ରିମିନାଲ appeal ଫାଇଲ କରିଛି
719
7719 of 2012 ଏଇଟା ରିସିଭ ହେଲା ହାଇକୋର୍ଟରେ 17/4/2012 ତାପରେ ଏଇଟା ଫାଇଲ କରିଛି। ତ 2013 Right. JCRLA number 21 of 2012. The appellant Raju alias Rajesh Behra in this JCRLA I challenge the impugned judgment and order passed by the learned ad hoc additional session judge FTC Bhubaneswar in CRL TR case number 47/205/2010. Judgment and order dated like 30/11/2011. In convicting him under section 395 of the Indian Penal Code and sentencing him to undergo RI for 5 years and to pay fine of rupees 3,000 in default to undergo RI for 3 months. Since the appellant has preferred a separate criminal appeal, that is CRLA number 719 of 2012, which is sub judice before this court challenging the self-same impugned judgment, this JCRLA is disposed of. तापरे ए तीनटार गोटे कॉमन जजमेंट करिवे JCRLA नंबर CRLA नंबर 21 of 2012 फाइलटा स्क्वाड दियंतु 21 of 2000 नहीं तापरे CRLA 21 of 2012 CRLA number 21 of 2012 has been filed. The appellants in appellants Vaikuntha Bhoi and Prashant Naik in CRLA number 21 of 2012, comma. तापरे एटा दियंतु 504 of 2012. The appellant Vishnu Naik in CRLA number 504 of 2012 and the appellant Raju alias Rajesh Behra in CRLA number 719 of 2012. Faced trial in the court of so and so for offences punishable under section so and by so and so, they have been convicted. Prosecution case कर देवे, है ना? What is your full name, Learned Counsel?
Rasmiranjan Naik.
Non appears for the appellant. Appellants for them in CRLA number 21 of 2012. So also for the appellant in CRLA number 719 of 2012. है ना? Mr. Rasmiranjan Naik, Learned Counsel for the appellant Vishnu Naik in CRLA number 504 of 2012 is engaged as amicus curiae for the appellant so and so in CRLA number 21 of 2012 and CRLA number 719 of 2012. The Learned Counsel for the appellants argued that since as per the first information report, 4 unknown persons committed the crime, চার্জশিটটা দেখো। এই এটা দেখো, সেগুলো এটা দেখতে legible হন ফাইনাল ফর্ম। And 4 persons face trial 4 persons, namely Raju alias Rajesh Behra, Vaikuntha Voi, Vishnu Naik, and Prashant Naik, faced trial. And in the charge, there is nothing that they, along with others, committed the crime. And from the evidence of PW4, the informant, it also appears that 4 persons participated in the crime. The framing of the charge under Section 395 of the Indian Penal Code. So also the conviction of the appellant under Section 395 IPC is not sustainable in the eye of law. Learned counsel further argued that the informant being examined as PW4 has stated in the chief examination that he knew appellant Vishnu Charana Naik and Rajesh Behra. And throughout his deposition, he has also stated what overt act has been committed by these 2 appellants. But all the same, the names of these 2 appellants are not there in the first information report lodged by PW4. Which creates doubt about any acquaintance with the 2 appellants, any acquaintance of PW4 with these 2 appellants. Learned counsel further submitted that in the cross-examination, PW4 has stated that he did not know the appellant Rajesh Behra prior to the occurrence. And police conducted TI parade in which he identified appellant Rajesh Behra. The learned counsel submitted that the test identification parade report indicates that only 2 appellants, namely Raju alias Rajesh Behra and Vishnu Naik, were placed in the test identification parade. And they were identified by PW4. There is no material against the other two appellants, that is Vaikuntha Bhoi and Prashant Naik, except the confessional statement of appellant Raju alias Rajesh Behera, which was stated to have been recorded by the investigating officer bracket PW8 on 22/6/2010 as per Exhibit 4. The learned counsel further argued that even though the investigating officer stated that at the instance of the appellant Raju alias Rajesh Behera, one black color money purse with a colored passport size photograph of the informant so also matriculation, a Xerox copy of the matriculation certificate of the informant and original PAN allotment letter of the informant and 600 rupees notes kept inside the money purse were recovered as per seizure list Exhibit 5. But neither the money purse was placed in the test identification parade, nor it was identified by the informant bracket PW4 in court during trial. The money purse photograph, Xerox copy of matriculation certificate and the 600 rupees notes were marked as MOs by the investigating officers bracket PW8. Learned counsel further argued that there is absolutely no material on record that when the that after the two appellants who were placed in the TI parade were arrested, were kept under covers so as to exclude the possibility of being seen by the informant prior to the test identification parade. And the magistrate who conducted the test identification parade has also not been examined. And in such a scenario, it is a fit case where benefit of doubt should be extended in favor of the appellants. Land Counsel for the Mr. Tripathi Land Counsel appearing for the state, on the other hand, submitted that as it appears from the case records, for the appellants Vaikuntha Bhoi and Prashant Naik, no test identification parade has been conducted. And those two persons were also not identified by the informant during trial. However, he submitted that since the appellant Raju alias Rajesh Behera and Vishnu Naik have not only been correctly identified by PW4 in the test identification parade, but also in court. And there was recovery of the money purse, photograph, xerox copy of the matriculation certificate, and original PAN allotment letter of the informant, and 6 number of 100 rupees notes at the instance of the appellant Raju alias Rajesh Behera. The London trial court is quite justified in holding the appellants guilty. Adverting to the contention raised by the London counsel for the respective parties, and coming to the charge framed in this case, it reads as follows. For the charge. Needless to say that the first information report was lodged against 4 unknown persons, and the informant being examined as PW4 has also stated about participation of 4 persons in the crime. In absence of any material on record that 5 or more persons have participated in the crime, the ingredients of the offense of dacoity as enumerated under section 391 of the Indian Penal Code are not satisfied. And therefore, when there is no charge that these 4 persons, along with others, have committed the crime, the conviction of the appellant under section 395 of the Indian Penal Code is not sustainable in the eye of law. PW4, the informant has not named any of the accused persons in the first information report. Bracketary Exhibit 1, and that is how it was lodged against 4 unknown persons. However, in the examination in chief, PW4 has stated that he knew the appellant Vishnu Charana Nayak and Rajesh Behera. He further stated that while he was waiting near Master Canteen, a Maruti Omni van being driven by appellant Rajesh Behera arrived near him. He further stated that the appellant Rajesh assaulted on his head, squeezed his neck, and asked him to deliver all his belongings. He further stated that appellant Vishnu Nayak was all along assaulting him. Thus, from the chief examination, it appears as if PW4 knew the 2 appellants, Vishnu Charana Nayak and Rajesh Behera, prior to the occurrence. If he knew the 2 appellants and they participated in the occurrence, it was expected of him to mention their names in the first information report. But since the names of these 2 appellants do not find place in the FIR, their involvement becomes a doubtful feature. In the cross-examination, PW4 has stated that he did not know Rajesh Behera prior to the occurrence, and police conducted the TI parade, wherein he identified Rajesh Behera. It is the prosecution case that only one TI parade has been conducted in Jharpada jail, which was conducted by the magistrate who has not been examined. However, the TI parade report has been proved as Exhibit 2 by none else than the informant, bracket PW4. If PW4 had got scope to identify the appellant Rajesh Behera in the police station, then the sanctity of TI parade, which was conducted at a later point of time by the magistrate, is lost. The prosecution has not offered any explanation as to why the magistrate who conducted the test identification parade was not examined to prove the report, in as much as many things the defense could have brought out by way of cross-examination to the magistrate regarding the illegalities or procedural infirmity, if any, conducted made in during commission of the TI parade. There is absolutely no material on record against the appellants Vaikuntha Boi and Prashant Naik, except the confessional statement of co-accused Rajesh alias Rajesh Behera, which has been marked as Exhibit 4. No TI parade was conducted in respect of those two appellants, and even the informant has not identified those two appellants in court during trial. PW4, the informant has stated that the accused persons took away his mobile phone and money purse from his pant pocket. He has not stated that his passport photograph was there in the money purse. He has not stated that his Xerox copy of matriculation certificate, original PAN allotment letter was taken away by the accused persons. He has not stated that the money purse was having 6 numbers of 100 rupees notes. Even though, as per the evidence of the IO bracketary PW8, are the instance of the appellant Raju alias Rajesh Behera, one black color money purse, passport photograph of PW4, Xerox copy of matriculation certificate of PW4, and original PAN allotment letter of PW4 and 6 numbers of 100 rupees note which were kept in money purse was seized as per seizure list exhibit 5. But since no test identification parade has been conducted in respect of the money purse, and even PW4 has not identified the money purse and other documents seized as per seizure list exhibit 5 in court during trial, the recovery of such articles cannot be a factor to hold the appellant Raju alias Rajesh Behera guilty. There is absolutely no material as to when that when the appellant Vishnu Naik was arrested and after the arrest of the appellants Raju alias Rajesh Behera and Vishnu Naik, what precautions have been taken by the investigating officer to conceal their identity so that they will not be exposed to the informant while producing them in court, so also taking them to the jail. In view of the foregoing discussions, I am of the humble view that the impugned judgment and order of conviction under section 395 of the Indian Penal Code is not sustainable in the eye of law. Accordingly, the 3 appeals are allowed. The appellants are acquitted of the charge under section 395 of the Indian Penal Code. They are on bail. The bail bonds, they are discharged from the liability of the bail bond. Surety bonds are cancelled. Put a note of appreciation on both the counsel. Since the Mr. Rasmi Ranjan Nayak was engaged as amicus curiae for the appellant Vaikuntha Boi and so on so in the 2 criminal appeals, a sum of rupees 15,000 shall be paid to him by the registry. That's all. After lunch, we'll take a vote.
Item 11,
What is the conviction here?
Here, 392. Initially 395 रे charge ହେଇଛି, but subsequently 392 ର conviction.
So
There are 7 accused persons. Out of them, 4 have been acquitted. 3 been convicted. First ରେ 2 ଜଣ ଅଛନ୍ତି, second ରେ ଜଣେ ଅଛି। Sorry, second ରେ 2 ଜଣ ଅଛି, first ରେ ଜଣେ।
So they have been granted bail.
Yes. Second attempt CRLA 152-12 रे bail was granted in 2013.
Okay, so nobody is appearing. We have to engage someone. Okay, next case.
Pardon my lord. I may be allowed to do this case. Item number 11.
We'll see that. Wait. Yes, item number 12.
Item 12. Item 14.
My name is there. Paperwork I have not received.
Give paperwork. Red pencil. Come to page number 53.
I have also not seen it.
Paper will be. Maga. ଦେଲେ କହିଥିଲେ ମାନେ କଣ ଘଣ୍ଟେ ପରେ ଦେବେ ନା ଡାକ୍ତର ସୁପରିଟେଣ୍ଡେଣ୍ଟ Fine. Hmm? The counsel for the appellant. 29/8/2018. So why didn't you collect the paper book and get ready in this case?
Sorry, my lord, I do not remember.
You are in the panel of the legal aid.
Yes.
Then so this matter was also there in the when it perhaps last week it was there.
No, my lord.
Last week only caused this thing. File दिया.
First time कि my lord.
केते थोड़ा matter list रे आसे देख. कोनटा कौच कौन? हाँ, list ये दे file दिया.
Item 15.
May I please, Your Lordship? The appellant has
You
been
have received the
convicted.
paperwork. Give the paperwork. Yes.
And the appellant has been convicted under section 376 2I, read with section 4 of POCSO Act, and sentenced to undergo RI for 10 years with a fine of rupees 5,000. In default, to undergo RI for 1 year.
Paperwork asla. Ki anitala. Doctor.
Case prosecution has examined 8 witnesses and exhibited 13 documents. PW1 is the victim, and PW, who is the doctor who examined the victim. PW3 is the father, the informant in this case. PW4 is the
Who
mother.
has lost the FIR?
PW3 father. The FIR is at page number 24, Exhibit 3.
State Council go to receive an endorsement paperwork received for the Yes.
Exhibit 3, page 24 is the FIR.
Please place the FIR.
माननीय श्रीयुक्त थानाधिकारी केउंझर महाशय निवेदन अभिप्राय यही कि जे मु सो एंड सो अटे गत ता 27/11/2015 लिख मोर झियो
This is PW1.
yes my lord
PW4.
May I make it clear to your lordship? Item 42.
Item
Please, your
39.
lordship. This matter your lordships had heard. Just to recapitulate some of the facts. The petitioner before your lordships seeks your lordship's indulgence and permission to have his passport back to travel back to USA.
Let's see.
He is in line.
Mr. Naik on his legs, let's say.
No, he is there.
Is there? Okay.
He's just online. I think he's online.
He just sent me a WhatsApp.
He's on. Yes, he has come. He is online. But the entire issue is because that whether I should be granted my passport for going for a limited period to USA, where I am staying as a green card holder mostly. But the basic, may I just tell your lordship in a nutshell? Yes. The prayer made is to release of the passport to go to USA as a green card holder for a temporary period of 2 months. Yes, sir. Yes. Yes. 6/12/23. Yes. That is not refusal. Refusal by the court to grant. Your Lord, refusal of the court to grant. Lord, yes. Yes.
Page 21.
Your Lordship get that it starts from page 21 and 6/12/2023 is the order. It starts at page 21 and 21. Page 21. Yes. Essentially is at the time of grant of bail, there was a condition that the passport shall be surrendered. And the passport was surrendered. Then we applied for the passport to go back to USA for a temporary period of 2 months for the reasons stated, which I will bring to your lordship, reason, which have very serious consequences to be. That has been, having been refused, I have come before your lordships in this application. The passport to be surrendered. Passport was directed by the court while granting of bail as a condition on the conditions of bail. When the bail order was passed, no.
9/10.
9/10 order. Yes, I will also a copy of that order. If not, I'll give that. Please give that. Please, sir. Yes. Bail. Yes. But I appeared and our bail was immediately granted, but the condition, extra condition was, yes, surrender the passport. So now I wanted to go back for a temporary period of 2 months for the reasons which are stated before the court below, which I'll state. Yes. Court, yes. Yes. So, but the orders.
Yes. The order, your lordship, is reflected.
On the petition itself.
Petition is here.
Yes. But the order reflects, but I'll give.
No, in the order, it's a. Yes.
Your lordship is not audible.
No. Mr. Naik, I just asked that whether you have filed the petition that was filed before the London court for release of the passport, and if any objection was filed. Mr. Mukherjee said that yes, that is there, but he has not annexed it. So it's all right. Please pass on that.
Yes, sir.
Not only the petition, but also the objection.
Yes, that has been there in the order, but you'll also make a copy.
No, let me go through.
Please.
Let me see that why you are seeking for release.
Yes.
Which paragraphs are relevant according to? Have you got a copy?
No, I don't know your lordship's copy.
No, I will not.
Mr. Padi, how can you argue unless you
I know.
When a copy be served to me, your lordships, the matter may be taken up on Monday. I have to go through it also, your lordships. The file it
Reflected in the order.
No, that is, I understand what.
but I need to read it also.
I understand what.
What is the reason and
Yes,
why
yes.
there was an
But
objection?
yes. Milord, I understand what your lordship is saying, but the only thing is Mr. Naik knows. Milord, I'll just tell your lordship the last. The reason which of course, I'm not given the copy. The reasons are threefold, Milord, which is reflected in the order, which is reflected in my petition, is one, I am a green card holder, Milord, in USA, and unless I reach the USA by May, then my green card will not lapse. My green card, Milord, what happens, Milord? Just tell your lordships, of course, I'll file a petition, give them a copy. There's no, but that has been mentioned both in my petition as well in the order. But may I just tell your lordships the reasons? Milord, I am a green card holder, and as a green card holder, Milord, from 1996, I have business in India, and my family is in USA. My wife, my children, my father-in-law, everybody is in USA, but I have business in India. Since I have business in India and I've traveled 44 times in the between. But I am a green card holder. The green card holder has a stipulation, unless I reach there by May, by May this coming month, then my green card will lapse. That's A, my reason. B, my lord, my reason. Your lordship asked me reason. And the allegations against me.
No, what is the green card?
Green card. I am a USA green card holder.
What is the advantage of that green card?
The green card, as you also know, if I'm not a green card, means like a citizen of USA. Like I'm a citizen of India, but if I'm as you also know, in USA, you get all the benefits of USA if you are a green card holder. But as you don't need visa to go in. In the green card holder, means you can do business, you can do everything. Otherwise, there are two types, my lord. One is that you're a tourist visa, which you go for 6 months. The other is green card holder. That means you stay indefinitely, you can do job, everything. You can accept voting.
Mr. Padi, then there must be a procedure as to how a person would be entitled to get the green
I
card.
have got green card.
You have got it?
I have got.
So suppose, and that must be for a particular duration.
Duration, unless it requires renewals. It requires renewals.
So
that
there
renewal
must be
is
also
due.
the procedure that how it is to be
renewed.
Whether for the renewal,
if
the
I'm not
presence
there, is required.
to vary that provision.
So far as provision,
Because if these things can be online.
No, cannot be done.
No,
yes, I understand. I'll just tell you a lot. Yes, Lord. Yes, there is this USA. I've got it, Lord, for the
because what Mr. Mukherjee should have, all these things should have brought on record that in fact what would have been the practical difficulty.
Lord, I'll just tell you. Lord, probably Mr. Naik will agree. Mr. Naik will agree.
He's asking for the petition.
Then I'll give you the petition.
Agree with what?
Lord, I'll just tell you a lot. Okay, I'll tell you a lot. Lord, this is how the left side and the right side. Left side is there is an allegation. Lordship also has an idea of the allegation against me. The allegation is that I am not a cheat fund company or anything of that sort.
No, I will not, I will not totally.
No,
go
because
into
of the magnitude of the offense. The magnitude of the offense is serious. The nature of because
no. If you have been granted bail, and question is that first thing is that whether there is any necessity.
Yes, to
number
go.
two, whether there is any chance that you will not return back.
I'll tell you. There are two things. Also, the magnitude of offense requires that if the magnitude of offense is very high, the chance of not coming is very high.
By the way, what is the stage now?
The stage is only charge has not been framed. Nothing has happened.
So
nothing has happened.
And you want for 2 months?
2 months only. Okay. But I'll tell you, Lordship. Right. And in fact, my facts are absolutely covered by a judgment of Supreme Court. I'll just replace them, Lord, to judgment. But just a gist of allegation against me, because gist of the allegation is I received, means my company on which I am the director, received 2.5 crores, not surreptitiously, by RTGS in 2009 from a company which later on found to be a cheat fund company. I have received only. I have nothing to do with cheat funds, or I have received an amount. Whether there will be an offense or not is a matter of trial. That's a matter of trial. Whether it will be offense or, like, my lord, just an example, my lord, a car company receives 5 lakhs from a cheat fund. He will not be liable for an offense because you can bona fide. So if I can bona fidely show that my receipt has nothing to do with the cheat fund not, and it's all open. That's number one.
No,
2%.
the
Your Lordship,
case
sorry.
said,
please.
the case said that first case in 2014 they said
2000.
that this money trailing aspect is to be investigated.
Yes,
in.
then
that is how the CBI came into.
And 2002.
Your Lordship, sir is talking about the car.
Naik, Mr. Naik, please just
Sorry, I'm sorry.
I'll hear you,
Yes,
Mr.
yes,
Mr. Naik will. Well, 2009, this money was transferred. 2014, the CBI took up the cases. And in 2022, a supplementary charge sheet, I was implicated. I got a charge sheet solely and wholly that 2.5 crores has come through RTGS from that company to my company. That's the entire case. Why I tell your lordships that when your lordships are considering to grant permission or not to go for 2 months or 4 months or 1 month, A, what is the necessity? B, what is the offense against me? Because if the offense is very serious, the likelihood of not coming is more. Because if you are a person who has thousands of crores and done here, like all these Nirav Modis, obviously the reasons are different. My reason, Lord, second, Lord, I have a well-established company structure in India. I have got 3 projects going on. That's the reason, Lord. If in the first place, if I had no need to abscond, I need not have come to USA from India. That is the number 2. Lord, number 3, my Lord. Exactly the same thing was considered. Exactly the same thing. Nothing. Let's kindly say this. And I have paid, my Lord, or rather, they have frozen 2.6 crores. 6-7 crores is with them. My money of 2.67 crores is with them to start with. I mean, 2.67 is secured by them. And they kindly see, my Lord, the judgment. Just.
Okay.
Yes. That's absolutely, my Lord, almost covered, unless slight difference of fact maybe, but Lord, the Lordship may kindly see para 131, para 2, page.
Yes.
Yes, Lord. Lord,
which paragraph?
Sir, I'll just use 7, 8 paragraphs. I'll put the relevant portions. Kindly turn to para 2 from the 5th line. The appellant sought, if you also got that, the appellant sought.
Paragraph 2.
Sir, paragraph.
Yes, yes.
Paragraph 2 after 4-5 lines. The appellant sought the leave of the High Court to do so since as a green card holder, it was mandatory for him to return to the USA within a stipulated period of his departure from that country, failing which the conditions for revalidation of that would not be fulfilled. Same thing is applicable to me, Lord. The High Court declined to relax the condition imposed by it for the grant of entry bail on ground that an affair has been registered against appellant for a long period, etc. Lord, your Lordship may skip over. Then kindly come to page 3. Page 3, my Lord, para 6. The appellant is an Indian citizen. I am also an Indian citizen and holds an Indian passport. I also hold an Indian passport. He holds a green card enabling him to reside in the USA. As I told your Lordship, what is the advantage of green card? That he can reside in USA. He has resided in the USA in 1985. In my case, my Lord, I am residing in USA from 1995. That is almost 30 years back, Lord. 91, I am residing, got the green card in 95. However, between 10th March and etc., the appellant visited India on 16 occasions. My Lord, I have given an affidavit, I have visited 44 occasions. That's part of the affidavit. Lord, then your Lordship sees, then kindly go to page 7, Lord. Page 5, Lord.
So just need to know the citation, your Lordships.
Citation, actually, it's a judgment, Mr. Naik. If somebody is there in your office here,
You
then
can give me the citation.
I'll give you a copy. I'll give him a copy. If you have,
But tell the party's name.
Mr. Naik, you have received a copy, I think. The same thing, it is Parvez Nurin Lokanwala. Yes, right?
Yes, Mr. Mishra has given me.
Yes.
Lord, then your Lordship kindly turn to page 5. Then this is the condition also in tab C. Before his actual release from jail, if you also get it from jail, the appellant is directed to surrender his passport. In that case also, passport and green.
Which one?
Here,
that condition of bail.
That same condition of bail.
Okay.
Same condition. Then we filed an IA. They filed an IA for that return for a short period for revalidating green card. Among them, following the same reason, Lord. Then the Lordships turn to page 7. the ground. The appellant, Lord, may I just substitute the grounds? It will be almost similar, but facts will be slightly different. So kindly turn to page 7, Lord. This was the condition on which was contended with the Supreme Court. The appellant is a resident of USA since 1985, holds a green card since 2010, and has not violated any provisions of the law in the USA. Notice see condition number 4. The 2015, the appellant visited India. The family, below this is important, para 5, the family of the appellant, which includes him, his brother, except 2 sisters, jointly, etc., what more than crores and appellant, only my family looking after litigation. Below here in India, we have a full running business of construction activities. Not that I can leave that and go away. Then the Lord says, kindly turn to page 8. Para 7, while the court grants bail under etc., can impose conditions which ensure the presence of the accused to face trial, the conditions must balance the liberty of the accused and not result in the arbitrary deprivation of the right to livelihood. But in the para 12, the Lordship says Mr. Jha submitted the appellant will undertake to come to India on every hearing of the criminal case before the concerned court. Then will the Lordship be pleased to turn to page 9. Para 14, the language of 436, etc., which uses the expression any condition, otherwise in the interest of justice, has been construed in several decisions of court. So the competent court is empowered to exercise its discretion to impose any conditions for the grant of bail. And for that, then the discretion of the court has to be guided by the need to facilitate the administration of justice, secure the presence of the accused, and ensure that the liberty of the accused is not misused to impede the investigation, overall the witness to obstruct the course of justice. Several decisions the court have been dealt. There are many decisions that have been dealt with. I will not disturb your lordship with all the decisions. Then your lordships turn to page 10. They have quoted from this decision that the conditions must be reasonable. Then para 17, this is important, Lord. In the context of conditions, etc., this court observed that the balance has to be struck between rights of the accused and the enforcement of the criminal justice system while imposing conditions of granting of justice. Lord, then they quote Barun Chandra and say in paragraph 9 that there could be no gains in that the right to travel abroad, Flossie got that, is a valuable one and an integral part of the right to personal liberty. Equally, however, the precondition of securing the prior permission for traveling abroad is based on seeking the justice. Then your lordships can straight away go to the page 12. They in the para 19. They rely on such large number of decisions where their permissions were granted to go abroad. And then the penultimate paragraph is important. 24.
24.
Sure.
Page number.
Page number 80.
Yeah.
Having regard to the genesis of the dispute, as well as the issue as to whether the appellant is likely to flee from justice, if we are to be permitted to travel to US, we find on the basis of previous record of the appellant that there is no reason or justification to deny him the permission, which has been sought to travel to the USA for 8 weeks. Here, the 8 weeks I have just stayed for 2 months, almost the same. The appellant is an Indian citizen, holds an Indian passport, but it is true that an affair has been lodged against appellant and we should not still prevent him traveling to US, where he is a resident since 1985, particularly drawn to the attention of the High Court and his court that serious consequences would ensue in terms of invalidation of the green card if the appellant were not permitted to travel. The record indicates that a large amount of litigation exists in family and travel with the US and India. Even after filing a complaint, we are according the view that the application of modification was incorrectly rejected. The High Court ought to have been allowed to travel to US for a period of 8 weeks. We accordingly permit the appellant to do so, subject to furnishing an undertaking to this court before the date of travel that will return to India after the expiry of a period of 8 weeks, that he shall be available on all dates of hearing before the court of criminal jurisdiction unless specifically exempted from personal appearance. The undertaking shall find before the undertakes travel. On his return to the appellant after 8 weeks, become necessary for him to travel to US, shall apply to the concerned court for permission. Exactly the facts, there are 3 reasons, There are 3 reasons there and the 3 reasons more. In fact, my reasons are more serious. There are three reasons I've stated in my petition. 3 reasons have been dealt with the court below. Now before your lordships. A, my green card is going to be invalidated by May end. because it takes time, my lord, after your lordship grant permission to go. Second, my lord, my two daughters, one daughter, what that?
Passport has.
He's required. His passport for his renewal, presence of both the parents are required. Like
She's a US citizen.
she is a US citizen. My father and mother. Mother is there, but father is here. That is second. My mother-in-law is in the ventilator. And there is no reason of, and there can't be any for fleeing justice because my full-fledged companies are here. And B, my lord, the only reason the learned counsel for CBI is objecting is that as if I wanted to try to flee. I'll tell you, lordships, this, I'll explain to that. But there was a NBW against me, NBW was issued against me for not appearance, though summons had been not issued. But after knowing that there was an NBW, I came before a lordship, this court, in another petition before, not now. And when this court, I think Mr. Nayak was also appearing, I've got the judgment copy. I'll give you a copy of the judgment. Justice Mishra's judgment. The NBW was quashed. They said that CBI had no reason to issue it. They quashed the NBW, but said that you appear. After I've got that. The relevant paragraph, I'll tell you lordships about this. After the NBW was quashed, my lord, before I had not, there was no direction. I had not applied for bail. Before the NBW was quashed, I wanted to go for US for a short visit. When I went for a short visit, there was a LOC, which I am not aware. It's called lookout notice, according to them. Circular, lookout circular. So because of LOC, they said that no, you can't go. Notwithstanding the NBW was quashed, there was a lookout circular hanging against them from long because the lookout circular and NBW are simultaneous. So once there's a NBW, there's a lookout circular. NBW was quashed, but the lookout circular, but whatever reasons, I didn't. Then I appeared before the court, granted bail in the same date with that condition passport. So there's no question of that I was trying to flee justice. My lord, I was not fleeing justice, and my lord, number one, my lord, lords have seen the accusations against me. It is not a kind of accusation where normally anybody would flee justice because 2 lakhs. That is my.
Yes, Mr. Nayak.
Yes, Your Lordships. Your Lordships, pursuant to the.
Yes.
Lordships, I would like to take Your Lordships to the background of the case before going. And last date of hearing also, Your Lordships had asked me if somebody goes to USA and doesn't come back, if Your Lordships will remember, what are the remedies which is available under the law? 2 questions Your Lordships had asked me. Number 1, what was the stage of the case? If Your Lordships can see the last order. In last order, 2 pertinent questions were asked by Your Lordships. And my learned senior was referring to some judgment right now, whether in that judgment the stage was of registration of the FIR or the accused was charge sheeted, Your Lordships, I could not follow. Charge sheeted, na?
Charge sheet.
I made a query to you,
Yes.
Mr. Nayak, that what is the stage of the proceeding in the trial court, and you took time to obtain instruction. Then another thing is that London Special Public Prosecutor shall also obtain instruction to meet his apprehension that in case the passport is released in favor of the petitioner for a temporary period and he does not return back to India during that period, whether any procedure is available under law to trace him out and to produce him before the London trial. So this is the.
Yes. Now, Your Lordships, I've got a letter, instructions. I would like to read it, Your Lordships. We have, Your Lordships, extradition treaties between USA and India. And there is one mutual legal assistance treaty between USA and America since 2005, Your Lordships. But Your Lordships, it is extremely difficult to extradite a fugitive from USA to India. And I would also like to draw the attention of the court, Your Lordships, despite several efforts, 2 of the accused, Your Lordships, might have heard of them, Mr. Donald Coleman Headley and one Rana, who were facing trial for the involvement in the heinous 2008 Mumbai terror attacks, Your Lordships, have not been extradited so far. Till now, Your Lordships. From 2008, we have been trying till 2024 for extradition. Till now, we have not done that. Number two, your lordships. Sir was talking about the background of the case, your lordships. Your lordships, pursuant to the order dated 2014 volume 8 ACC page 768, the court at that point of time has categorically stated that three aspects of the investigation has to be taken into consideration, which your lordships have cited in many judgments: the money trail part, the larger conspiracy, and the involvement of several other persons. Court at that point of time, Supreme Court was absolutely categorical that you leave no stones unturned. So when Sir was talking about giving one example of some car company, your lordships, CBI has charged people, those who have taken second-hand cars also. Forget about company, your lordships. Because this was the direction of the court that you don't leave anybody. And in money trail part, this Indrajit, they came. Now, your lordships, the provisions of the IPC doesn't depend on the quantum of the punishment, quantum of the, or the magnitude of the amount involved. If somebody is accused of 3,000 crores or 2,000 crores, the provisions under the IPC remains the same. So the chances of the conviction doesn't depend on the magnitude of the amount involved rather than the gravity of the offense, your lordships, with due respect. So if Nirav Modi will abscond because the amount is 2,000 crores, 5 crore person will not abscond, depends on the quality of the evidence, not the quantum of the money, with due respect. Now, your lordships, this accused, sir told that NBW was quashed. It's a fact that NBW was quashed. But after the NBW was quashed, your lordships, he was trying to abscond.
Not abscond.
Because he told the court, your lordships, my learned senior, with due respect, must be having the dates. The High Court order, if I remember, your lordships, was on 18/7/2023. After that, your lordship, the first summon was issued on 4/8/2023, your lordships. The second summon, your lordships, he took time on the first date. The second summon was on 14th August, your lordships. Then on 28th August, your lordships, he told that, kindly give me time. I'll come in the next date of hearing. In the interagnum period, your lordships, on 30th August, he was apprehended from the Kolkata airport. If he didn't want to flee and he was on bail, what prevented him or stopped him from going to the trial court, getting a bail, taking the permission of the court, and then going to USA, your lordships? Why he was going to Kolkata airport instead of coming to the court when he has taken a time from the court that I am going to appear in the next date of hearing? Lord, this fact can be clarified by the learned senior counsel also, that when he had taken time, categorically, that I want to seek time, give me some time, next date of hearing I will go. The time taken was to go to court, not to USA, your lordships. Therefore, he was apprehended by the Kolkata airport by immigration, and which I have put on the affidavit. Your lordship may kindly come to paragraph 8 of my affidavit for a moment.
Paragraph
8
of what?
Of my reply, your lordships. Paragraph 8 of my reply of the CBI. And moreover, your lordships.
That was detained in the airport, that was saying. That
Yes.
Paragraph 8. Okay.
Yes. The Honorable High Court of Orissa had passed order dated 18/7/2023 with the direction of the London Trial Court to issue summons to the accused. Further summons was served to the accused, but instead of appearing in the case before the trial court, he continuously took time. Though counsel, by various reasons, repeatedly for a long gap, meanwhile tried to fly abroad without informing either the trial court or the Honorable Court, which is nothing but a grave violation of the order, because the High Court order was that summons will be received and you go and appear before the court. It is a fact that he was deported from Kolkata airport by immigration authority with the undertaking for surrendering before the trial court. Thereafter, only the accused surrendered before the trial court on 9/10/2023, your lordships. Therefore, he did not go as a gentleman and sought bail, your lordships. He was trying to flee.
No, this prior to this order.
Yes.
Prior to this order, the NBW order was quashed, and
yes.
What is the operative part of that order? That is not available with me. That was quashed on 28 July 2023. Okay. Then it is directed that the court below shall issue. This is the.
Yes, that is operative part.
The court below shall issue summons for appearance of petition number 3. Which petition number 3 here?
Yeah, I was the petitioner.
Petition number 3. Okay.
Sure, only summons. Court directed that the summons be.
It goes. No. Petitioner number 3 is this person.
Yes.
Yes.
Petition number 3 very.
Yes.
Okay. Goes without saying that the court below shall be at liberty to act in accordance with law if person fails to abide by so and so.
Yes.
So this order was passed on 28 July 2023. Then when the summons were issued?
Yes. First summon, your lordships, was issued on 4/8/2023, in which they sought time.
Just a minute.
Yes.
4/8/23, first summons issued. Yes.
Lordships had seen the record 1 month back. The second summon, your lordships, I think,
The
was issued
summons
on.
issued that to appear in person or by pleader. When we appeared in through pleader, then
Yes.
they issued summons. Then thereafter, my lord, thereafter, just to clarify this fact only, thereafter we received summons, we appeared to the dates.
No, your lordship, that's a wrong statement. I think
appeared
sir
means
no, you never
court,
appeared. No,
to the
never appeared.
lawyer, to
On the next day of hearing,
to the
again,
lawyer, not in person.
Please.
Appeared to the lawyer, the 2 dates. Then thereafter, my lord, thereafter, since there no restriction, taking into consideration the summons and issued and we have appeared, we had that's the requirement. We went to it USA, but we are not aware. There's a lookout circular also because of that NBW is hanging in. They didn't arrest us. They detained us and sent it back that you go and apply for bail.
No, can you please give me this? What happened from this 4/8/2023?
Yes.
Is the order sheet is available?
Yes, order sheet is there.
Lordship, may kindly read the order dated 4/14 and sir, if sir can correct me, the third date.
4/8/23.
That was the 28th August, your lordship, if I refresh my memory correctly. Third date is 28th August.
4/8 order is there, my lord. Associate price Baklatnama in India verified 4/8.
This is the summon.
Summon and the order.
Thereafter, he said that.
Yes, sir.
It's your order.
Bail order is
Summon in summon and we appeared on that 4/8.
No, he said again, 4/8 you though appeared through the lawyer.
Yes.
Then another date was fixed.
Yeah, 4/8.
Because the court insisted for personal appearance.
No. In fact, in the bail order itself, if I also have got that copy of
What is saying that assurance was given for personal appearance, then trying to flee away.
Not trying to flee.
28 Swanson.
There was a direction for personal appearance, which we have avoided. Thereafter, my lord, only issued notice, we appeared and all that. But in fact, in the bail order, if you also got it, my lord, in the bail order itself, he has observed.
नहीं ये जो इतने बड़ा लंबा ऑर्डर था जी यादर पूरी से जो लाइन टा ये अंडरलाइन कर दियो see if so far as this particular
that person that you had appeared that you had
Indrajit there say sari reference se whether you have taken time for personal appearance so
no
that
time, no there was only
that was the submission perhaps
there's no direction for personal appearance.
Time is allowed, right?
Time is allowed. Time was allowed by the court. Allowed. But in fact, my lord, one more thing I'd like to point out to lordships. In the bail order itself, the court says that he has never been attempted to flee justice, which is being stated is, if lordship take the court's view. The court itself, when it granted bail, said that the accused has not attempted to flee the justice process of law. But this is there in the first bail order. Your lordship is asking for that first bail order.
So this case,
yes.
If this time is allowed, means it when this order was passed. This is 28/8/23.
Yes.
Then the date was fixed to. No, it is something else, Mr. When the date was fixed here.
Sir, may I tell us 3 dates?
Put up on 11/9/23.
Before that, the so-called.
Yes, Mr. Padi, this order clearly indicates
yes
that Indrajit they files a petition praying for time for his appearance. Time is allowed, and then the next line is put up on 11/9/23 for appearance of the accused Indrajit Dey.
And the person who is holding up me is on 4/8. 11/9 date is there. I was to go 11-9, date was there. 11-9.
Your Lordship, for 11-9 date was there. I will
There.
manage.
Before that, my lord, before that, for a short visit when I was going to USA on
How can you go to USA, Your Lordship, when a date is issued?
You said that he was just picked up from that airport.
Airport,
and
because LOC.
produced in
Not produced. They had just refused me to go.
Okay.
No, they are not.
Then you appeared on 38.
They on 38, the petitioner, when I was going for USA was prevented by the immigration at Calcutta on the ground that the LOC was against me. And in fact, in the bail order granted, which your lordship have got a copy, but I'll again say that the accusers never attempted to flee justice. So
that was the finding in
that is the finding in the bail order. So there's no concept of fleeing of justice because, my lord, I was going to USA, which was not allowed to go because of the ex-LOC, which is hanging against me for.
Sir, we can take up tomorrow.
Yes.
After
2 o'clock, if your lordship possible.
Mr. Naik will take up this matter
2 o'clock
tomorrow.
Same
matter is item number
Yes,
30.
both the matter will come.
Here, my lord, what has happened, my lord? According to your lordship's direction, I have filed the bail order and that passport. Last order, your lordship directed. And my lord, I have filed a application for amendment of the cost schedule as well as fare. Then inadvertently, there is a mistake that the old passport number I have mentioned. So let that be.
We are taking up both
I have
the
a small
matters.
request, Your Lordships.
But one
39.
I have a small request, Your Lordships.
Yes.
Your Lordships, I don't have the copy of the order sheets. If my learned senior can.
We will give to your associate here. Or
all the
whatever
orders. Yes.
All the orders I'll give to your associate. He can scan you copies. I'll give you to associate. Just tell him to contact my office.
Keep it tomorrow.
Thank you.
You kindly tell him to contact him. He'll give you all the copies.
2 o'clock, item number 30, 39 and 40 tomorrow at 2 o'clock it will be taken up. You place a note in the down below that these two matters.
Your Lordship, there is a part heard. Instead of 2 p.m., 3 p.m. Just 3 p.m. please. There is a part heard matter which may continue, Your Lordships.
This is also a part heard matter. This is also
no.
This is also
just decide. I'm there till.
No, Mr. Naik.
3:30 to 4, Your Lordship can take it.
No, 3:30. Sorry, Mr. Naik. If you think that the time to the this is also a part heard and this is also a.
I'll take only 5 minutes.
This is also a constitutional court. So same thing.
So,
Lordship, I'll try my best. In case I can't come, then
2 p.m. Your Lordship, grateful, sir.